This is a lecture in the area of personal injury law. It's taking place at the Center for Advanced Legal Studies in Houston, Texas. And I'm an instructor here. My name is Tom Swanson. And I want to start out by doing a little recapping. The primary subject of the lecture today is negligence law. However, I want to kind of go back to the beginning a little bit and let's do a little review. First of all, what is personal injury law, or what it is known by in its traditional name, torts? Well, personal injury law is an area of substantive law. It defines the rights and duties of people. And in particular, with respect to personal injury law, it deals with claims for compensation due to injury to body, property, or rights. And this definition is important because a lot of people tend to think that personal injury law is all about sore backs and sore necks, when in fact there's a great deal of personal injury law that doesn't involve physical injury, but involves injury to property or rights. When you talk in terms of a personal injury claim, there's really three critical components. The first is liability. Liability means legal responsibility, and in the context of personal injury law, it asks the question, can someone or some entity be found legally responsible for the injury to someone's body, property, or rights? So you have the liability that has to be proven. Then, assuming that you can prove liability, then you get into, are there damages that can be proven? And by damages, this is a remedy, if you will, in the form of money. However, it's not enough to just say the word damages. It should be better said as legally authorized damages. Not all harm or to someone is compensable in damages. For example, something like embarrassment is oftentimes not compensable in terms of damages. So that's the second part. You have to establish, legally authorized damages. Finally, and this is a real world situation, not so much a technical legal situation, but in the real world, then comes, how are you going to get the money? What is going to be the source of actually obtaining money if you get a judgment? Now, a lot of times it's through insurance. In insurance, it depends upon, how much insurance is available. But insurance is a major source of actually collecting on the damages that are sustained by someone in a personal injury case. Beyond that, then it comes to the issue of, can the judgment be enforced against the defendant, the one who caused the injury to the person? Well, that's going to depend on a lot of things. Obviously, if it's a company and the company has assets, that may suffice. However, oftentimes there are situations where someone has a valid liability claim, that they have significant damages, but there just isn't a source to satisfy it in terms of actually getting paid. So all three of those things have to be present for there to be really a successful personal injury claim. Now, personal injury it originated in a body of law which is called the English common law. And the English common law was basically a body of unwritten law that began to be disclosed centuries ago in terms of court decisions. Appeal courts would actually discuss what the common law is, and that's still the case today. 49 states in the United States have adopted the English common law, so it's a big part of personal injury law in the United States. Now, you have appeal courts in the various states, and they don't always agree totally with each other on what the common law is or the extent of the common law. So that's where it began, in England with the common law. There are four basic categories of personal injury liability. The first and oldest is called intentional torts. And this is misconduct that's either on purpose or presumed to be on purpose. So, for example, if someone were assaulted, that person could bring a claim for assault. That would be an intentional tort. If someone deliberately trespassed on your land, that would be an intentional tort, and so on and so forth. These are some of the oldest personal injury claims. The second category of personal injury liability is negligence. And negligence is given various definitions. One is a failure to exercise ordinary care. My definition is, and I think it's a pretty straightforward one, is conduct or misconduct, I should say, that is accidental but careless. And the vast majority of personal injury claims are negligence claims. So it's a big area, covers a lot of situations. The third category is what they call strict liability, and this refers to certain situations where there is liability without showing fault. There are two that typically, that in these situations, these strict liability situations, that liability is based upon control of some instrumentality. For example, claims based upon defective products can be strict liability claims. That means that they could be held liable even if they weren't negligent. So if you have a defective product and that defective product causes injury, then there can be a recovery, even if there was no negligence. The idea is the manufacturer was the one in control of the manufacturing process. Therefore, it's more just that the manufacturer suffer the loss of an injury caused by the product than the consumer. The fourth category of personal injury liability is what is known as statutory torts. This refers to personal injury claims created by the legislatures. And as an example, it typically deals with two situations. One is where there was no common law claim that existed, and therefore it was essentially added to the body of personal injury law by legislation. The second situation is it may have been a common law claim, but it has been so modified by legislation that it really doesn't stay within its common law boundaries. Examples of statutory torts would be claims against governmental entities, because in the common law you couldn't bring a claim against the sovereign. Other examples would be things such as many types of consumer claims. The common law was not very kind to consumers, so most of our consumer protection laws and personal injury are statutory in nature. So those are a couple of examples. Our focus today, though, is going to be on negligence, and we begin with what we call the elements. Every claim, whether it be a personal injury claim, contract claim, there are requirements that must be met. And these are called elements, what you have to produce evidence on in order to have a claim. In personal injury, and negligence in particular, there are, depending upon if you use a traditional approach to defining elements or a more modern approach, the traditional approach is that there are 6 elements of negligence. Number 1 is called the existence of a legal duty. That doesn't make a lot of sense if you don't work in the field, but basically it means there is a legal duty imposed on someone to exercise reasonable care as so not to harm others. So for example, the most common negligence claim probably is car wreck based types of claims. And so you sit there and think about it. If you get into your motor vehicle, what duties do you owe to the people around you? Well, they have various ones. Like one is timely apply your brakes. Another would be to maintain a proper lookout. Another might be to yield the right of way when appropriate. Okay, so there are various duties that flow from just operating a motor vehicle. Well, you have other kinds of situations, such as land-based personal injury claims. These could be construction accidents or defects on the premises that cause injury, like a hole that you can't see and someone steps in it and gets injured and so forth. The point is, every negligence claim begins with this legal duty. Now, where do these legal duties actually come from in the law? Well, there's several sources. One is contracts. When you enter into a contract, you're making typically a legally enforceable agreement. Okay, if you violate that agreement in the contract sense, well, you have a breach of contract. But what if you have a failure to perform the contract properly and someone gets injured as a result? Well, then the question becomes, you didn't perform your duty, and therefore someone got injured. Therefore, it's more than just a contract claim. It's a personal injury claim. Let me give you kind of an example. Let's say that someone rents an apartment. A lot of times people do things and they don't analyze them. But if you rent an apartment, basically you have this contractual relationship with the landlord. Typically, the landlord is in charge and has authority over the common areas of the apartment complex, the walkways, the parking area, whether or not the premises is fenced and gated, and so on and so forth. The tenant does not have control of that. So, let's say that someone sustains an injury due to a dangerous condition in the parking lot, let's say. Okay, there you have a negligence claim, but it's based upon the duties arising from the contractual relationship between the parties. So contracts are sources of legal duties. Statutes and ordinances, such as city ordinances, can be the legal basis for duties and negligence claim. There is a well-known case in Texas called Nixon versus Mr. Property Management. And in that case, this was, I think, in the Dallas area, but I'm not positive. In this case, there was in Dallas. There was a Dallas ordinance that required that unoccupied apartments be locked, both in the windows and the sliding glass doors and the other access doors, that they be locked. Well, someone was abducted off the sidewalk by an apartment complex and taken into an unlocked, unoccupied apartment and assaulted. Well, in the Nixon case, while recognizing that typically when someone's a crime victim, the major responsibility is on the perpetrator, but they pointed out that it can also include others, and that because the failure to obey the city ordinance facilitated the opportunity and location for the crime, that the apartment complex could be held liable depending upon what the jury decided. So again, you have these statutes. I'll give you some common situations, and that deals with where you have activities that are governed by OSHA statutes. And for example, if you're dealing with a high-rise construction project, there's a variety of OSHA safety laws with respect to scaffolding and decking between floors and wearing lanyards so you can tie yourself off so you don't fall, things of this nature. So the violation of an OSHA statute can be the basis for a negligence claim. Finally, there are some traditional rules of common law that come into play that are sources of legal duty. Let me give you an example. Let's say you have a situation where you have a swimming pool. And this swimming pool, let's say it's residential. A child gets access to the pool and drowns. Well, you might say, well, was the child supposed to be there? Well, under the common law, it doesn't necessarily matter if it's a child. They have a rule called the attractive nuisance rule. That is, it recognizes that little children don't understand property boundaries and that they tend to be attracted to certain things and get involved in things they probably shouldn't get involved in from time to time. So the attractive nuisance rule, the violation of it, which is a common law rule, can be the basis for personal injury liability. So that's how you determine the existence of a legal duty in negligence. Now you go to element number 2, which is the breach of the duty. Now, remember, this term breach is B-R-E-A-C-H. It's not the upside down baby. And breach means simply some form of violation. So if there's a violation of the legal duty, that's your second requirement. The third requirement is what they call actual causation. There must be some linkage between, it may be tenuous, but there must be some linkage between the breach of the legal duty and the injury. This is sometimes referred to as but-for causation. But for the breach of the legal duty, this event wouldn't have taken place. But in negligence law, that's a threshold causation. There's another level of causation that must be reached called proximate causation. And I'm not saying approximate with an A, I'm saying proximate, P-R-O-X-I-M-A-T-E. Now, there have been tons and tons and tons of cases that have discussed proximate causation and what it is, and they kind of torment you in law school with it, but basically it comes down to this. Was it foreseeable that the kind of breach of legal duty would be one that could cause someone injury? So, for example, if you don't timely apply your brakes and you strike another car, is the failure to timely apply your brakes a situation that could cause injury? Is it foreseeable? Yes, it is. And then there are other times where it isn't. And, there's a number of cases that go through whether or not something's approximate causation, whether or not whether it reaches that standard. Sometimes the distance is so remote that the approximate causation is simply not there. So if you establish now the duty, the breach of the duty, the actual causation and proximate causation, then you get into injury, okay? Now, if it's bodily injury, that means harm to the physical structure of the body. If it's property damage, it means, that the property is somehow physically damaged or diminished in some way. So you have to reach that injury threshold. If there's no injury, it's like there's no harm, no foul. Then you get into the sixth element, which is damages. There must be some damages recognized by law as a consequence of the injury. Okay. For example, something may be said that hurts your feelings. Well, the thing is that oftentimes the law doesn't compensate hurt feelings. You see. So there you have it. There are the elements of negligence. It applies to all claims of negligence. It's your checklist, if you will, of proof that will be required to establish a claim. If you fail with respect to one of the elements, you don't have a negligence claim. Okay. Now, there are times where someone may be excused from liability in negligence. And this is true of many claims, but we'll talk about negligence in particular. Sometimes there are sets of facts that limit or eliminate liability. The formal name of these situations are affirmative defenses. It refers to sets of facts that limit or eliminate liability. Typically in personal injury law, they don't say affirmative defense all the time, they just say defense. But there are a number of defenses to negligence claims. Let's talk about one that's very common, and that is the statute of limitations defense. Under the law, you have a certain period of time to file suit and enforce your rights. Now, this can vary from state to state. Some states may have 2 years, some states may have 3 years. It just depends on the state law, because most personal injury law is state law. So if you fail to timely file your suit to enforce your rights, that's a defense. You don't get anything. Your claim is defeated. Another example, and probably the most common, is what they call, in the common law, contributory negligence. What this means, what was the victim's conduct in connection with the accident in question? So, for example, let's say that someone is in an accident and they're injured, and the other party hit them, making a turn, and that the defendant shouldn't have made that turn. It was careless to make that turn, but the injured person, the claimant, was speeding at the time, or didn't have their seatbelt on, something like this, something that contributed to the injury that was considered negligent. Well, in the common law, if the injured party, the claimant, was 1% negligent, they got nothing. Over time, states enacted statutes, which they refer to as comparative negligence statutes. And these statutes vary from state to state. Let me tell you about Texas's version. In Texas, let's say that the jury finds that there's $100,000 in damages. They find the defendant 90% negligent, but the injured party, the plaintiff, the claimant, 10% negligent. Well, under Texas law, the defendant would be assessed a judgment of $90,000, even though the damages were $100,000. Why? Offsetting for the injured party's own negligence. Now, in Texas, this works down to 50%. In other words, if in the same situation, if the injured person were 50% negligent, then the defendant would only be required to pay $50,000. However, if the plaintiff's negligence is over 50%, under the Texas scheme, the plaintiff gets nothing. Now, there are some states that have a pure comparative system, to where that, let's say the plaintiff was 60% negligent and the other party was 40% negligent. Well, the defendant would have to pay $40,000 to the plaintiff. But that's not the case in Texas. It's all statutory. All right, we're going to take a brief break and return shortly.